The Nigerian Bar Association has warned the police against resuming enforcement of the tinted glass permit policy, now arguing that the matter is still before the courts and that any action now would amount to contempt. The association says past enforcement was marred by harassment and rights violation and insists citizens must be protected from unlawful practice.
If it is a crime-fighting measure by the police or policy by the police, and not a money revenue-making one as we contend it is, and as it is indeed, why can't this data be obtained at the point of renewal of your vehicle particulars, which involves the police, the customs, the state security service, and the licensing authority? Why is the IG so interested in compelling members of the public to pay money into a private account? And there's a lot of opacity. How did they arrive at the amount being paid? How is this money being spent and shared? If it is for public purposes, why is it not being paid into federal government account through a TSA account?
Meanwhile, the Supreme Court has affirmed the president's constitutional powers to declare emergency rule and suspend elected officials, stressing that such measures must remain temporary. Together, these developments highlight the ongoing tension between executive authority, judicial oversight, and the protection of civil liberties. Tonight, we explore what this means for Nigerians and the country's democratic institutions. Well, joining me to shed the light on this and discuss extensively is Echoga Nicholas-Caleb, is a partner at Chayfield Law Practice. He joins live from our Abuja studio, and also Emmanuel Sogo, a trial attorney and transaction advisor, also live at our Abuja studio. Gentlemen, thank you for your time.
Thank you for having us. Thank you, Dapo.
All right, let me start with you, Nicholas. Nicholas, let's look at the tint permit, will I call it, issue right now that has started generating reaction. The police has said it will resume enforcement of the tint permit policy. But the NBA is arguing that, look, this cannot happen because it's a case still in court. For the average Nigerian right now, maybe who has a car that, you know, the glass is tinted, they're at crossroads. So, I mean, what is right here, or what do you perceive as right here, and what is wrong?
Well, for me, and I believe, you know, lawyers across Nigeria would agree with me, if we're being honest, right, from a clear legal standpoint, you know, that statement from, you know, the police PPRO, you know, it's saddening, really, you know, because this points to a very crucial fact as to how do people perceive matters that are before the courts. You cannot say that there hasn't been a specific pronouncement. I mean, about 2-3 months ago, you know, a lawyer in Delta State approached the Federal High Court in Warri, right? And he got, you know, an interim order of that court. And that order, right, was for parties to maintain status quo ante bellum. It basically means that the whole enforcement of tinted permits, right, was not to go on. So it's really saddening and confusing as to why, you know, the police will make a statement to say, you know, there's no interim order of court and that enforcement will continue, right? That's not fair. That's not justice. And the NBA is right to, you know, to challenge that. And I commend, you know, the leadership of Mazi Afamosigwe, you know, that has come out immediately to say this matter is still before the court. I have not seen, as a lawyer, perhaps maybe they would educate us, right? Or maybe perhaps the legal team, right, for the Nigerian police force needs to actually educate, you know, the police as to the effect of subsisting orders of court. I do understand, yes, that the Federal High Court in Abuja, right, there was a pending interlocutory application on this same matter. And I understand that parties had agreed amongst themselves to withdraw that pending application, but the senior advocate representing the Nigerian police force had made an undertaking to the court to say, you know, we are going to maintain status quo while the court makes a pronouncement. So for the police to now come out 3 days after that undertaking in court, right, to say to issue that statement, it's highly unfair. And I mean, on the face of it, it's contempt of court.
All right, what's your take on this, Emmanuel Sogo?
Well, I'll take a slightly different approach whilst arriving at the same conclusion, particularly with respect to the issues at hand. Now, for starters, we need to understand that the orders under reference, which is ex parte in nature, that was issued by the Federal High Court sitting in Warri Division, are ex parte in nature. Those orders, by virtue of Order 26, Rules 10 of the Federal High Court rules, are supposed to only carry on for a particular period of time, particularly 14 days, by virtue of the Federal High Court rules. So relying on that, the Nigerian police force can actually make an argument to the extent that the orders under reference have elapsed by a fraction of time. But however, by virtue of the undertaking that was made by the learned senior counsel for the Nigerian police force at the Federal High Court on the basis that parties are supposed to maintain status quo ante bellum, the counsel speaking from the bar is supposed to enjoin his clients, which is the Nigerian police force, to actually maintain status quo on the doctrine of sub judice, which is the fact that where matters are pending in court, parties are supposed to respect the procedure and allow the procedure to get to a foreseeable end before taking any further step.
All right, I would like to read, a quote or some of the things that the police PRO did say. In his words, he said the Inspector General of Police, out of respect and understanding, temporarily suspended enforcement to give Nigerians additional time to regularize their tinted glass permits. Now, that decision was not based on any court order, but on discretionary move to accommodate public concerns. However, I did acknowledge that the matter is currently before the courts, but also noted that the legal process has been slow and stressed that pending any contrary court ruling, the status quo allows the police to continue enforcement. Just before I get back to you on this, Nicholas, he went further to say the position remains that enforcement continues until a court directs otherwise. At no point did any court refrain or restrain the Nigerian police force, Inspector General of Police, from implementing the tinted permit order. End of quote. This, of course, is his position on this matter. What you've given is on the contrary. Where's the middle ground here? And I'm talking to you, Nicholas.
Yes. The legal basis for what I had said is still the order that had been made by the court sitting in Warri, right? My friend Sogo had mentioned that, yes, it's an ex parte order, right? But when a matter is before the court, it's sub judice, right? It's, as our training, what our training dictates as lawyers, and which is what we should be able to tell the public, right, without fear or compromise of any sort. That when the matter is before the court, you know that there are issues that need to be determined. It only behoves on the parties that are before that court, particularly when the court has made an order, albeit ex parte, right, to respect, the status quo. So that is the basis that I am making reference to. And again, I still refer, because you've asked me for, legal basis. I still refer to, the undertaking made by learned senior advocate for the Nigerian police force on the 12th of December, I think, right? That parties were going to we're going to respect status quo, meaning that, they had an understanding, right? That's the NBA and, the Nigerian police force. They had an understanding that the status quo would be maintained. And to that effect, he made an undertaking. Now, the law is clear, right? The authority is Lagos State versus Ojukwu, where a counsel makes an undertaking to the court, that undertaking that he has made before the court is even enforceable. And to a larger extent, right, he has bound himself, not only himself, but more importantly, he has bound the Inspector General of Police and the Nigerian Police Force, which he represents, and they can be held for contempt.
All right, thank you for your insights on this. We'll go on our first break. When we return, we'll expand the conversation to look beyond this tinted permit saga, to look at what seems to always be the communication gap or the issue between enforcement of duty by the Nigerian police, what the law says, and of course, how this affects the general public and interface. Stay with us, we'll be right back. Many thanks for staying with us. It's still Politics HQ on News Central Television. I still have my guest with me. I have Echoga Nicholas-Caleb, is a partner at Chayfield Law Practice. And I also have Emmanuel Sogo, is a trial attorney and transaction advisor. They're both at our Abuja studio. Gentlemen, thank you for your time. Now, I would be coming to you, Emmanuel, and I would like us to explore this issue where there seems to be, from time to time, what I call a clash right now, clash of interest and duty between law enforcement, particularly police officers, what the law says, and civilians. So this tinted permit issue is a typical one. I mean, we've also had cases of checking of phones where countless times you hear statements like, look, an officer is not meant to check your phone. You know, it's not within his jurisdiction except he has, you know, some sort of second-tier permission or, you know, a court order and all of that. But in reality, that seems not to be the case. So what do you consider the missing gap here, especially from the angle of what the law says versus what is being experienced in reality when interfacing with law enforcement?
Law enforcement and the applicability of the relevant laws, it simply has to do with issues surrounding lack of proper orientation with how the law should be applied. I believe that law enforcement agencies at the point of recruitment should be properly trained on how these things should be done. Because most of them, when you get to interface with them, you find out that they are lacking depth with respect to how they are supposed to perform their duties. So I believe that with proper orientation and the right mindset and the right framework, these sort of issues will not arise in the coming future. However, I would like to just bring to the fore a particular interesting point, which is the fact that just today, with respect to the tainted permits, which is under reference, the topic for discussion tonight, the Delta State High Court has actually issued an order restraining the Nigerian Police Force to not enforce that particular directive that was issued. So I believe that based on that particular order that has been issued today, the Nigerian Police Force would actually maintain status quo because they were hanging on the fact that there is no subsisting order, particularly because the previous order that was issued in Warri, Delta State, has actually elapsed by a fraction of time. But the fact that this particular one is subsisting, it means that the Nigerian Police Force would actually maintain status quo.
All right. I would also direct the same question to you, to Emmanuel, but with a bit of caveat here. The reason why the police seems hell-bent on the issue of tinted permit is because they claim that criminal elements, you know, are using that as some sort of advantage to carry out their nefarious, you know, activities, and for that reason they need to step up. So we sometimes have conflict, you know, in the line of duty in terms of being able to be efficient and effective and what the law says. I mean, as a lawyer, how do you recommend or advise that they navigate these complexities? Did you get my question, Emmanuel?
Oh, I thought that was for...
Sorry, I'm sorry. That question was for Nicholas.
Okay. Yes, I heard you. These complexities of carrying out, their duties, as you've mentioned. Like Emmanuel had mentioned, there seems to be a gap in terms of, the persons who are even recruited, as officers, right? There needs to be, orientation on a large scale, right? The police is supposed to be seen as a friend. The police is supposed to be seen as a helper. The police is supposed to be seen as, people that you can approach, right, in terms of crises and all of that. Now, the approach that the police should take, even beyond trying to enforce some of these policies and all of that, how much time has actually been spent on enlightening the public, right? That's where the police, their public relations, the National Orientation Agency, that's where they should come in. If the public is largely enlightened as regards, the benefits of some of these policies, perhaps we wouldn't face some of these kinds, of resistance. But you have instances where, it just seems like the police wants to hide under the guise of, we're trying to prevent crime per se, crime rates are high, and all of that. If I were to ask, the police already has the powers, right, under the Police Act. If a vehicle, if you see a vehicle as a police officer, you are empowered to stop that vehicle, right? Carry out your stop and search activities. It's part of the police powers, regardless of whether that vehicle is tinted or not. So the guise of hiding under the excuse of security is just bogus, and there's no basis for that, really.
All right, gentlemen, I'd like to, of course, say a big thank you. But before I let you go, just a quick one to you, Emmanuel. Emmanuel, as a, well, I call it a young Nigerian, and of course, just like many other Nigerians, there seems to be a bit of trust gap between the average citizen and, typically the police. You hear a lot of people say, oh, they don't trust the police. They've been, victimized at some point or the other. But I'm going to ask you, what do you think can be done to sort of reinforce the trust between the average Nigerian and our police force? What can be done to mend that trust?
Well, the thing about trust generally is that once it is broken, it is very hard to fix. But it is not enough for us to complain about the problem. We need to see how these problems can be solved. So the way forward, by my perspective, I believe that the police needs to act right moving forward. For the police to gain the confidence of the public, the police needs to act right. The police needs to do what is right, not by their own thinking, but by the books, by the law. And once that is being done, I believe that the general confidence of Nigerians will be restored, and the police will indeed be seen as your friend, as they usually say.
All right. Now, Nicholas, just to digress slightly, let's also look at the emergency rule, which, of course, has been upheld by the Supreme Court, and is generating reaction that the president can actually has the right to suspend, within the context of the emergency rule, an elected official for a temporary base. Many are raising the question, even though this is what the law says, is this right?
So it's like you rightly said, a lot of reactions have come out since that judgment was made. It's a very interesting one. One of the interesting things the Supreme Court did was it had actually mentioned that it had no locus. I wonder why Supreme Court had told that part in its wisdom. The Supreme Court is not just the apex court; it's also a policy court, a court of policy making. And I think it's tactically avoided having to deal with the merits. So, to be clear, two things the court had actually done. First, it had stated clearly that the president actually has the power to declare state of emergency. But as regards the merits of the case, right, which was on the issue of whether it could suspend, the court didn't make a pronouncement on that. What the reactions people have been hinging upon at best is an obiter of the court. There was no binding statement on as regards whether the court had endorsed the removal of Governor Sim Fubara. It was an obiter statement, and I mean, as far as I'm concerned, right, there has been no pronouncement that we can hold on as a binding precedent that does empower the president to do what had happened in Rivers State. So for me, there is no binding decision from the Supreme Court in that regard. Perhaps we'll wait for a situation where an actually aggrieved party, elected official, actually approaches the court, and then we can get to hear the court's decision on that. Those are my thoughts.
All right. How about you, Emmanuel? Particularly the precedents this is setting.
Well, the decision of the Supreme Court with respect to the emergency rule in Rivers State is a very interesting one. But I'd like to look at it from this perspective after reading the judgment on the reference. I believe that the Supreme Court actually stated emphatically, although in passing, that the president actually has the powers to declare a state of emergency by virtue of Section 305 of the 1999 Constitution as altered. But the Supreme Court went further to make analogies with India and other countries as to what should be done after a state of emergency should be declared. In some of those jurisdictions, what needs to be done is the fact that the president assumes the powers of that particular state. But the Supreme Court talked about the fact that for Section 305, in our case, it is actually silent on what needs to be done after a state of emergency has been declared. So by virtue of that particular pronouncement, I believe that the Supreme Court has actually made an inference that the fact that the Constitution is silent, the Supreme Court, as a matter of fact, said that the silence of the Constitution is deliberate. So the fact that the Constitution is silent on that point, it means that the president indeed does not have the powers to actually suspend the executive arm and the legislature after declaring a state of emergency. So to that extent, relying on the fact that one of the canons of interpretation that talks about the express mention of one excludes the other, it means that the fact that the Constitution expressly states that the president can declare a state of emergency but did not go further to state what needs to be done thereafter, nobody should actually import what is not contained in the Constitution into it. So to that extent, I believe that the Supreme Court, although an obiter, it could serve as some form of persuasive decision or a guidance to people that are aggrieved or states that are aggrieved moving forward, and it will actually set the right tone.
All right, gentlemen, I'd like to say a big thank you for your time on the show this evening. It's been a pleasure having you. Thank you once again.